think the most profound example is in civil jury trials. The Seventh Amendment absolutely guarantees a trial in matters involving more than, I think it's $50, whatever it was back in 1791 when they passed the Bill of Rights. Here's what's happened over the years. The Seventh Amendment says not only do you get a jury trial, a trial by a jury of your peers, but the fact findings they make, except in the rarest of circumstances, cannot be upset. So what the court has done, and I know there's lots of reasons, including mediation, arbitration, and other things that I think are not, I call it offloading justice. The finest way to resolve differences, in my mind, is through a jury trial. Then comes a judge trial. But this business of outsourcing justice it's just not what the founders intended. So what they've done over the years, starting with a triumvirate of cases in 1986 that breathed life into summary judgment, there were warnings then. Justice Brennan, in one of the famous 3 cases, the Liberty Lobby case, warned that if we breathe this kind of life into summary judgment, we're going to have paper trials at the end of discovery in every case, and that's what's happened. Discovery has become a profit center, and summary judgment, which is the key here to what's happened to jury trials, at least from the Supreme Court vantage point, jury trials in general, have shifted this fact-finding that juries were supposed to do to judges. The best example for me is Daubert and Kumho Tire, where experts' testimony is subjected to a gateway, they call it, a gateway determination by the district judge. And most of the states have followed it. And what that does was shift the responsibility really for determining the credibility, is what it comes down to, of an expert's testimony. The basis for his testimony, the tests that he ran, the methodology, etc. Now that's a decision, as Justice Rehnquist pointed out in his dissent from Daubert, that's a decision that was left to jurors for 200 years. Is this expert persuasive? Does this expert tell me something I don't know? And weighing that was the principal function of the jury, to weigh the evidence. And instead of overturning factual findings, the Supreme Court, with the help of liberals like Breyer, Justice Breyer, have moved the fact-finding process to judges and away from jurors. That's not the way the court was supposed to be set up. They call it, they've also done it at the beginning of the trial. They've created procedural hurdles along the way that have undermined the Seventh Amendment.